Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Hi, and welcome to the Southwest Florida Real Estate Update. I'm Michael York of the York Real Estate Group, and today we're joined by our host, Jim York, and his guest, Don Ross Jr., President of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Don,
Jim?
It's December, close to Christmas. Thanks for coming on the
What?
show.
Oh, geez, I got to shop.
So the viewers that haven't seen you, tell us a little bit about yourself.
Okay, I'm a local attorney. I've been here since 1985. Been practicing since '82. A real estate lawyer, tax lawyer. I own Ross Title and Escrow. I'm a shareholder in Downing Fry Realty. I've been their counsel for 25 or so years. Our staff at the title company, we have 4 closers, 8 employees. We do a fair number of closings. People seem to be happy. We're located on the corner of 6th Avenue North and 41. Good blend of experience, because most of my people have been with me 30, 20, 10 years. And when you're together that long, they know what I want, I know what they do. We assign them to a particular realtor. Less mistakes are made that way. Return phone calls, it's sort of a pet peeve of mine.
Well, I know our clients love your company and the people we deal with.
Appreciate it very much.
Today, the subject is going to be who's liable when people don't make the deposit on time or don't make the deposit at all?
Well, not you, unless you've done something wrong. Under the NABOR contract, if the buyer doesn't make a deposit, there's really nothing anybody can do, because the deposit in the NABOR contract is the liquidated damages. It's the damages that the sellers get if the buyer refuses to close for any reason at all. So if they never make a deposit, there's nothing the seller can do. The realtor's not liable unless the realtor made some misrepresentation, like the money's here when it wasn't, which happened back during the recession.
Right.
So as long as the realtor sticks to selling real estate, the realtor's not liable, the buyer's not liable, the seller's really stuck. Now, FAR-BAR is different. FAR-BAR, the seller can go after the buyer for the deposits agreed to be made. Mm-hmm. You got to look at page 1 where they define deposit. It's deposits made or agreed to be made on page 1. Right. And I think it's paragraph 15 in both FAR-BAR contracts that say the damages are the deposit. So I've had sellers go after buyers for the second deposit that wasn't even made yet. So really it's the seller, unless the realtor does something crazy.
In that scenario, who explains that to the buyer when he's doing it? The agent? Is there a timesheet of different things that they should be presenting to the buyer, and the seller should know that there's a timetable of events?
Yeah, it's a touchy area. I think NABOR has a timesheet showing when things are due, mm-hmm. But they invariably will, the buyer or the realtor, seller will call me and what's the effective date, even though it's on, I think, page 2 of the NABOR contract. And you count the days, and I literally take my iPhone out and I'm 1, 2, 3, and if it falls on a weekend or a holiday, it rolls over to the next business day. Right. Having said that, I always tell my buyers and my realtors, get it in early, because I don't want to have to count 1, 2, 3 with somebody on the other side who might be interpreting it differently. Different parts of the contract will say such and such happens X days after the effective date. Other parts might say X days from, which includes the effective date. So there's like a 1-day difference between those two hypothetical examples. So really what I recommend, have them call me, we'll be on the phone together, I'll count through it twice, that's the effective date, and then I'll recommend do it a day early. Don't get cute and try to push it to the outer limit, especially with NABOR, because you can go up to 11:59 at night. Don't do it at 11:58. I mean, that's ridiculous.
That's what I was, that's okay.
You're going to get somebody irritated and they're going to sue in spite of what the contract says.
And maybe I'm dwelling on this too much, but it's the time that you received that deposit, right? It's not the time that they wrote the check and sent it to you, or the escrow agent?
Effective date is a what they call a legal fiction.
Mm-hmm.
Okay, it's not when you have a binding contract.
Mm-hmm.
It's what they define in the contract as the start date.
Mm-hmm.
So it's the start date. That'd be a synonym you could use. FARBAR has a different effective date than NABOR. FARBAR requires delivery. NABOR is silent. Now, if I were writing an answer to a law school exam question on when do you have a contract,
Right.
it's when the offer is received by the other side, and is deemed to be received if it was mailed to you in the mail. As soon as the buyer drops in the mailbox, it's deemed to be received even though the seller hasn't got it. So whatever method they use, whether it's an email or just snail mail or hand delivery, if you use the same method, it's deemed received at that point. But then you get technical, are there mutual remedies? And I know NABOR has a provision that the initial deposit can be 3 days after the contract signed. It's really not a legal contract until the money is down.
It's down,
because
right.
you don't have mutual consideration from the buyer. What would the buyer lose if they default? Nothing. What obligation would the seller have if the buyer wanted to force it? Well, you could sue for specific performance.
Yep.
So it's an artificial start date, so you can calculate inspection periods, mortgage contingency periods, and all the other time periods that you have in the contract.
Yeah, because I explain that a lot to my buyers, or the sellers really. It's really not a contract till somebody puts the money down.
Yeah.
But what I was trying to say is that I think you answered this question was, the deposit's due today,
Right.
And you don't acknowledge that you received the deposit today,
Right.
In an email or whatever. We're going to go into that at the
Sure,
next segment.
sure.
But they put it in the mail, or I delivered it to your
Yeah.
office. What is the timetable there? What makes?
I mean, what I was taught in law school, I still, you go through school and you remember like the names of certain cases. Well, I remember the mailbox rule, they call it. If the offer was mailed to you, it's when you drop the signed contract back in the mail. Adams v. Linsell was the case. So they call that the mailbox rule. But these days everything's emailed.
Right.
So,
But the check, I'm talking about the check or the deposit.
oh, the check.
That's what I'm talking about. Yeah. When is that? If they put it in the mail, but it comes in after the due date that it was supposed to be there, or I take it to your office and one of the girls doesn't record it till
Right.
the next day. What's the timetable there? Or
As soon as it's delivered, as soon as the check is delivered, then you have a binding agreement, except again for FARBAR. Because
Right.
FARBAR, there's a promise from the buyer that they will pay. They promise to pay, and the seller can sue for that promise.
Right.
And in NABOR, the seller cannot sue for the buyer's promise to pay the second deposit.
That's right.
So FARBAR, it doesn't matter when it's put in the mail, the seller still can sue. NABOR, if it's not in my account, the seller's out of luck.
Right.
And it's looser, I think, just to protect realtors. If they get the days wrong, it'd be a little more accommodating.
Right.
I don't think most people understand the difference between whether it's a binding contract versus what's the effective date.
Right.
They think the effective date is the same as having a binding contract. It's not. But, it's good enough for government work, as they say.
Well, Don, we're going to take a little short break
Sure.
here. We're going to hear a little bit about the York Real Estate Group, and we're also going to have a little commercial about Don Ross and his big office here in Naples, Florida. And we'll be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Well, Don, we're smiling here.
What are we doing, Jim?
Yeah, what are we doing? So talk about those forms right there.
Well,
what are they for?
These are to verify when escrows are received by the escrow agent, if the escrow agent is an attorney or a title company. This law and this part of the administrative code in Florida was passed in 2007. There were abuses going on at the time. People were lying about whether deposits were there. You know, sellers would sue for the deposit. They'd find out it's not there. So the Florida Real Estate Commission passed this, the legislature passed the statute as part of 475, and then they delegated the authority to prescribe rules to the administrative code. And what it does is it requires the selling agent to verify within 10 days of the due date of a deposit, or ask within 10 days of the due date of a deposit of an attorney or a title company, did you get it?
Right.
And you know, there's a form that's filled out by the realtor, part of it by the realtor, part of it by the escrow agent. I took 2 forms here that my office used. One example is where the realtor filled out the part they were supposed to, another one where the realtor didn't fill out anything, and what we do, we plug in the people's names and we automatically send it to the realtor just to keep the selling agent out of trouble.
That's right.
But it's a burden on the selling agent to tell the listing agent what's going on about the deposits. Part of the rule also require, and this is the part I actually like, this part I don't care for, but the part I like is they require that the sales contract identify who the escrow agent is with an email address and a telephone number, so people can independently verify, is the money there?
Yeah, it's right on the bottom.
And again, it goes back to 2007, and you had people saying deposits were in and they weren't. So the Florida Real Estate Commission stepped in and said, you, the realtor, have to verify this if you're the selling agent, okay? If the seller has the ability to pick who's holding the money, the rule doesn't apply. If the real estate brokerage company holds the escrow, the rule doesn't apply. My problem with the whole process was I grew up with my father as a realtor, and you and I have talked about this.
Mm-hmm.
Any successful realtor I have ever met always knows when the second deposit is coming in.
Yeah.
They check with their clients. They know when the inspector is going out. They know which bank they've applied to. They know who's fixing what. They know if the survey has been ordered. They're involved with the file in the whole process, and this seemed, except for putting on the contract who the escrow agent is and how to reach them, overkill.
Mm-hmm.
I mean, it's almost like trying to teach somebody how to be a good realtor.
Yep.
Being thorough, being involved in the process. I did make a phone call to an unnamed broker this morning asking, because when this happened I predicted that probably nothing would happen much.
Mm-hmm.
And I asked whether he had heard of any realtor being sanctioned over this in the last 12 years. The answer was no. To me, it's somewhat akin to the unauthorized practice of law. There was a big to-do over whether you could fill in the blanks of a lease that, say, maybe I prepared.
Right.
I mean, we have Florida Supreme Court leases that have been pre-approved that realtors can fill in the blanks. It's information only. You can plug in their names, the dollar amount, the term, but you're not allowed to draft legal language.
Mm-hmm.
That's the unauthorized practice of law. And for years, I mean, I mentioned in the intro, I've been the attorney for Downing Fry for 25 years. We used to have a pre-printed lease form by a local attorney.
That's right.
Everybody used it. There was never, ever a complaint, ever. and I predict it'll be the same here. Doesn't mean it couldn't happen. I mean, if somebody lies, you got a problem. You can be sued for fraud.
Right.
You could have an ethics charge. You could have an ethics charge, a NABOR charge, and a lawsuit. You get all three. So if you're going to lie or be deceitful, you're in a world of trouble.
Right.
You could lose your license. And there's fines in place for this, so it is a serious thing. I don't mean to minimize it, but fortunately, we're not in a situation where deals aren't closing. Most of them are closing. It's not 2007. We're not in the depths of a recession, so nothing's really happened yet with this. He is going to bring it up when they have their statewide meeting and ask if there's anything new. Supposedly they have new agents who can audit this. But good realtors do it anyways.
Yeah,
you should know when the deposit's coming in. You should be in constant communication with your buyer. You should talk about collected funds and how you do wires. You, the realtor, you shouldn't be handling the checks or the wire instructions. Have them call me or whoever's the escrow agent. Educate your people. So that's our escrow verification.
Well, Don, I appreciate you coming on the show, and I wish you a Merry Christmas.
Merry Christmas,
our viewers
too.
a Merry Christmas. And next month when Don comes on, which I'm always excited. Next year, I'm sorry. I'm always excited about this January shows because we go over the biggest mistakes that people made in the year prior to.
Don't get me excited, Jim.
So thanks again.